And with that, I'm going to turn the discussion to the Florida Building Code, which appears at Chapter 553, Florida Statutes, and this provides, again, another alternate remedy besides, perhaps a breach of contract or negligence or what have you. The Florida Building Code actually provides a statutory remedy or cause of action to anybody who has been aggrieved or damaged as a result of a violation of the building code. And that's under 553.84 is the subsection. And that applies to contractors. So if you are an owner of real property and the contractor has failed to comply with the applicable building code, you have, in addition to any other remedies you may have, you have a cause of action against your contractor for violation of the building code, but that's against the contracting entity. You cannot go after the qualifying agent, and I assume that in other jurisdictions it's similar as in Florida. But in Florida, in order to do construction work, you can't just simply form your corporation. Once you form your corporation, you then have to have that company qualified through the Department of Business and Professional Regulation. The Construction Industry Licensing Board issues that license. So you have to have a licensed general contractor, and then that license is now tied to the corporation, and that corporation is now allowed to engage in construction contracting in Florida. So if the contracting entity violates the building code, you can sue the contracting entity, but there's cases that say you cannot go after the qualifying agent, so you can't simply go after the license holder and sue him or her in their individual capacity. You'd be limited for suing the corporation for violation of the building code, and I cited a couple of cases there, and the Florida Supreme Court case directly on point is Murphy v. and Sinha Corp. 644 Southern 2nd 983. That's a 1994 Florida Supreme Court case. Now, the anecdote to that, or anecdotally, is that if the qualifying agent happens to personally engage in some conduct that is actionable, and I think in that case it dealt with a negligence claim, or even if it's a building code violation, if the individual license holder personally commits the violation, then I think you may be able to go after them personally. But if you're just dealing with the corporation and you can't point to some independent conduct from the license holder, then again, you're going to be limited to suing the corporate entity and not the qualifier. The statute provides a remedy in favor of an owner against even subcontractors and contractors who want to sue their subcontractors for violation of the building code can do so. That's under the Rosenberg v. Cape Coral case. And also architects. That's the Edward J. Siebert case, and I've cited that in the materials. And so architects are under a duty to conform their designs to the building code, and obviously, that would deal with any design professional. It could be an engineer or an architect. And failure to use due care in doing so could make the engineer or architect liable under the statute. Just a reminder, again, if anybody has any questions on anything that I've covered so far, feel free to ask. If I haven't yet covered it, again, feel free to ask, and if I'm going to cover it, I'll let you know, and if not, and I'm able to answer it, and if it's what we're discussing, I'd be glad to try to answer it today. Now, if you believe that there's been a violation of the Florida Building Code and you are thinking about suing under the statute, you should be mindful or aware that a remedy is unavailable where the person or contractor obtained all required permits from the local jurisdiction that issues permits, that the construction plans were approved for permitting, where the construction passes all required inspection, and there is no personal injury or damage to other property. And really, you see this theme throughout construction defect cases, not just dealing with this statute, but in negligence claims. And we're going to talk a little bit about the economic loss rule But where you've got personal injury or property damage, or you simply have what they call just economic damages or loss expectation damages. So in a situation where you have personal injury or physical destruction or damage to other property that's not the subject of construction, then this statute will apply. So really this is saying if you're only dealing with economic loss, and again, you pull all required permits, you pass all required inspections, and there is no personal injury or property damage, then there is no liability, unless the person or party committing the violation knew or should have known that the violation existed. So obviously, the contractor or subcontractor or design professional can't simply put their head in the sand. If they knew or reasonably should have known that a violation existed, they can't then fall back and say, well, I passed all required inspections and I obtained the required building permits and there was no personal injury or property damage, so therefore I'm not liable under the statute. So essentially, if they knew or should have known, then the statute can be used as a remedy. However, and I have to admit I'm probably guilty of this sometimes in drafting pleadings, where again when you're drafting a lawsuit early on, sometimes you're not quite sure what all the facts are. But Florida's a notice pleading state. You can have pretty scarce pleadings that could pass a motion to dismiss as long as you allege and plead ultimate facts that state a cause of action. You don't have to be super detailed in your pleadings here in Florida, and it may be different in other jurisdictions. But you can't just simply say that the person knew or should have known that a violation existed to try to get around the statute. At some point, if that's all you can allege, that is going to be deemed insufficient, and that's under the Cohen v. Hartley Brothers construction in case that I've cited in the materials. So hopefully, if you're going to make that allegation, you do your discovery, and hopefully you can point to some fact at some point to have some ultimate fact that shows that the contractor or subcontractor or architect or engineer knew or based on their knowledge, experience, or relationship to the project that they really should have known